Mark Geragos is their criminal defense attorney. He represented the Menendez brothers in their effort to have these convictions tossed. And Stacey Honowitz is an assistant state attorney of the Sex Crimes and Child Abuse Unit in Florida. And it's just delightful to have both of you reunited together on this program. First, Geragos, I'm going to begin with you. If anybody has news on this case, it's going to be you. We're getting perilously close to the window closing on when this judge has to give you an answer. Are you going to get your hearing? Are you going to get these convictions tossed out? And B, what am I hearing rumblings about that there actually might be other witnesses out there?
Well, I don't want to be presumptuous, but I'm hopeful, or as they say, cautiously optimistic, that His Honor will either issue an order or an invitation for the DA to reply informally, or issue a formal order ordering them to reply. And you're right, there is a time limit in which to do that. And so I'm hopeful. The one issue I take with the setup, as you laid it out, is that the first trial, they put on a defense. They had what was called imperfect self-defense. Half the jurors felt that it was not murder, that it was manslaughter. The second trial, something very unusual happened. The judge basically invited, not once, but twice, the district attorney, David Kahn, who's now passed away, to rethink whether imperfect self-defense should be there. It was at the judge's suggestion. And sure enough, finally, David got the hint, and the judge did not allow imperfect self-defense, did not allow some of the most compelling evidence to show the jury that there was abuse. And most importantly, the thing that galled me in real time, I was not their lawyer until recently, but in real time, what I thought was outrageous was to allow the DA, David, to argue that it was an abuse excuse, knowing full well that the evidence that would have supported it had been excluded. That, to me, is unbelievable. And that shows, and I have told you on and off the air, Ashleigh, if these were the Menendez sisters, they would not be in prison.
So that's somewhere I want to plumb right now with you, Stacey. And you're going to have to kind of wear two hats as a sex crimes prosecutor, but as also a prosecutor. So you're now hearing about, potential evidence that would support the claims that these boys made at their trial, that they were sexually abused, because there may be others who were as well. Is that enough? First, is it enough, do you think, for a judge to say, toss those convictions, let's start over, if there's even a will to do that? And then if there is another trial, is it enough in this day and age where sexual abuse is real? People do believe it. They don't think it's necessarily an excuse.
Well, listen, just because you're a prosecutor doesn't mean that you just look to lock everybody up or you will just seek justice at any expense. That being said, this is a very difficult case. I remember when it went to the first trial and it was a split decision. And then in the second case, as Mark said, this judge did not allow any of this evidence to come in. Now, when you talk about having this evidence of other people being abused, usually we talk about in the sense of the defendant abusing other people. It's called Williams rule. In this case, it's like reverse Williams rule. We want to show, in this case, that the victim was really the abuser. And so you really have a tough road to haul in this case. It's not that easy. Mark knows that it's not that easy to get something tossed. Do I believe that at some juncture a judge could look at this and say, this is new evidence, this is newly discovered evidence? On the flip side to it, why didn't somebody come forward sooner? We talk about this letter. Would the client not have told their own lawyer, I wrote this letter 8 months ago? If you don't believe that it's going on, call my cousin. So, these are things, these are evidentiary matters that if the court does decide to open it back up, that this is evidence that could be presented to make a determination as to whether or not, in fact, it was discoverable back then, and is it worthy now, 33 years later, of me bringing it back? Got to reverse himself, basically, because that's what happened in this case, to say that this is enough. It's in fairness and it's just for us to relook at this new evidence. I can't make that decision.
I am so fascinated. Yeah, I'm so fascinated with this. Tomorrow, we're actually going to talk about some of the things that have been going on in the prison, where they are finally reunited after decades of being apart and have been living in the same, cell area together. Former cellmates and folks in the prison, former inmates and guards, talking about what they're like. So I'll have to have you both back, because TikTok, Mark Geragos, I think we're getting down to just a matter of days until there has to be a decision. So will you come back on, both of you?
I go anywhere Stacey goes.
Me too.
You're the only one, but thank you.
Thank you both. I appreciate it. Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.